There
Now,
we go. Welcome
there it is.
everybody. Welcome everybody to Talking Niagara. You know what we need to do, you see, Angela, is we need the clapperboard, right? Because 3, 2, 1, wait for it, and you're live before we say a word.
Yep.
So welcome everybody to Spin Legal. It's November 20th, 2024, episode number 43. This is Angela Browne and Peter Giblett, in partners of Invictus Legal tonight, and our topic is going to be Introduction to the Law of Torts. So, it's an interesting one. I hope everybody's up for that. And hey, if you are, that's fine. If you're not, we'll see you at the next show. But don't go away before you understand what torts are. So some necessary introductions first. So if you need to contact Invictus Legal, you can do so on 905-688-5598 or contact Angela at weareinvictus.legal. Or myself at peter@weareinvictus.legal, or contact our website at https weareinvictus.legal. And we've got Robert DuPau. Hey Robert.
Hi, Robert. How you doing?
All right. My next one here is I've got to do this. So starting next week, we have got a CPD going on, and so starting next week, people can do this CPD, and I'm going to give you the link. So if you're a lawyer or paralegal, I'm going to drop the link into the comments right now in order that you can kind of sign up for it if that's what you're interested in. So there we go. On Spin Legal, Invictus Legal, and on my Facebook page, on my YouTube page. There we go. So
Yep.
you've got the actual link right there. Okay.
Yep.
So,
People can take it. They go there, and there's a fee for it. There's 3 evenings.
It's a 3-evening course, by the way. So it's 6 hours total, 6 hours 20 minutes total. But I think you can get 6 hours 20 minutes professionalism from approved by the LSO. So there we go. Right.
Mm-hmm.
So just let everybody know about that. And hey, if you're a lawyer or paralegal, let your friends know. We're going to have fun. It's starting next Tuesday, and it's on cpd.legal. Okay.
Yeah.
So
I always try to make them interesting.
Yeah. And Angela's going to be accompanying me, so that so we'll end up slapping each other around a little bit, won't we?
Oh yeah, we always have fun with those things.
Okay, so here's a question. We've done various topics on Spin Legal. We've done contract law. We've done some basics on LTB. We've actually dived into some pretty important LTB problems. We even talked about human rights at one point. So here's another topic we've going to go into is what is a tort? So, and I said tort, and be clear here, we're not talking about torts that are pies. We're talking about torts that are wrongdoings, okay?
Not the kind that you eat.
Yeah, not the kind that you eat. And hey, we should have, damn it, Angela. I should have gone out and gotten some torts for us to eat. Torts to eat on a tort lecture.
Yes, in a tort lecture, yes.
That would have been fine. That was the way to do it, wasn't it?
Yep.
Okay. So essentially torts are due to there's a fault, whether it is intent or carelessness. So that somebody has committed a wrong, either intentionally or carelessly, or unintentionally. So anybody can sue on this. You don't need to have millions of dollars to sue. You can sue in small claims court on torts, and you can You can sue in divisional court and above in torts as well.
Yeah, people have sued for all sorts of things, like
Yeah.
spilled coffee, right? When they went to McDonald's.
That's yeah, and in fact, actually, yeah, exactly. There was a coffee where they heated it up to God knows what temperature, and the person, sipped it and burnt their lips.
And they spilled it all over themselves, I think.
Yeah, that as well.
And
There's been a number of cases on that. Okay, so there we go. That's negligence is actually, for example, here's one example of negligence is I live on a hill. So to get into my house, I've got to park my car up the driveway. So let's say I park my car up the driveway, but I happen to forget to put the handbrake on. And a few moments later, you come walking by, and my car rolls down the hill and bangs you. Right?
and it won't be too happy.
That's an example of a negligence tort, right?
Mm-hmm.
Something you didn't mean it to happen. It happened. It happened by chance, and but again. The point being is my negligence caused Angela's injury.
Yeah. And other forms of negligence are through motor vehicle accidents.
Yep.
People who drive and get onto the road, they don't mean to smash into another vehicle. Okay? They're just doing something and they make a mistake on the road and then they smash. There's doctors who maybe in the course of doing surgery, they may perform and make a mistake and they can be charged with medical negligence. There's all forms of negligence, and it's nothing done that's an intentional thing to hurt anybody. That's why as professionals, that's why as drivers, that's why as businesses, everybody carries errors and omissions insurance.
Yeah, and we've talked about insurance and the need for insurance in various situations a few weeks ago.
Mm-hmm.
Right, and I'm sure we will talk about insurance in a future program as well, because
yes.
I think insurance and the law often go side by side, and we must never lose sight of the need for insurance on the legal side. Negligence is an important thing because it has three parts: 1, a duty of care; 2, a standard of care; and 3, there must have been a breach of that duty of care. So the duty of care is an interesting one. There's all manners of reasons why there's a duty of care. We talked about that car that I parked on the hill. I've got a duty of care in that regard to put the handbrake on or press the button that says hill parking, before I leave the vehicle, and not just leave it as if it was on a flat piece of road.
Mm-hmm. And this is something that when the negligence is also what they call, one of the tests is the but-for test.
Yeah. Well, there's a whole heap of things about this whole duty of care.
Actually defines that, and to discuss whether you can prove that an act was negligent or not.
Yeah. And probably people have heard also about, in terms of the duty and standard of care, probably people have heard about the snail in the bottle case, Donoghue versus Stevenson. And what in Donoghue and Stevenson, it's about whether there is actually a duty of care between the manufacturer and the ultimate consumer of the product, and that's where the House of Lords, or what is now the Supreme Court in the UK, actually defined that there was a duty of care, and that duty of care was breached in this particular case.
Mm-hmm.
And
you go to McDonald's. I mean, if somebody goes to McDonald's and something ends up on the burger that you ordered and makes you sick, there's a duty of care to make sure that everything is done to the standard that McDonald's expects to be able to serve consumers.
Well, not just McDonald's. I mean, what public health authorities expect.
Anybody who actually serves consumable products to somebody, hey, to make sure that things aren't in there. We've had a recall of bread for some reason about pieces of metal stuck in the bread, and the stores were told to remove all of them from the shelves.
Yeah.
And that's
Okay.
scary because one of the bread is a brand that I buy, but I bought it after the recall.
Yeah. Well, that's actually normally when that's the only item of bread that's on the shelf, because nobody wants to touch the recalled bread. Do they?
Yeah, they hear
Was
about it. I remember the big spinach case.
it this one
Yeah.
or was it not?
Mhm.
Okay, let's talk duty of care for a moment. Let's define duty of care.
So let's talk about it, Peter. What
Yeah.
is the duty of care when you are a business that is producing consumable goods?
That you basically, this is where you're basically saying that we have a duty to all users of those goods, for example.
Mm-hmm.
All right. And again,
They have a right to expect not to get sick by something,
yeah,
not to get harmed by something, and that sort of thing. When they take it, there's a certain expectation of type of product that they order. Okay? And then even when you go in to see a doctor, you have a right to expect that the doctor will perform at a certain standard, and you're not going to be more injured going out than you went in. Okay? So I mean, these things are being expected. So these things are very carefully prescribed by law. There is a certain standard of competence among professions, among businesses, and how they would circumscribe their duty.
simply defined, duty of care is a legal obligation imposed on uh, any individual, company, or anybody doing anything that requires an adherence to a standard of reasonable care to avoid careless acts that could foreseeably harm other people.
Yeah. And there's a foreseeability too, which is also another one that's very important because if something could be done, there could be a foreseeability. But then again, that's up to the plaintiff to prove that there could be a foreseeability within that particular case. Hey,
Yeah.
but we've looked at all of these things, and there's many cases like you go down in the middle of winter and then you walk down the street and you slip and fall on a sidewalk, and then you hurt yourself, you injure yourself. It doesn't necessarily mean it's automatic a lottery win for the city, like some people think. Hey, it is an issue where,
or even from the shop owner who,
yeah,
or let's
mm,
say there's a shop owner or Sam's
mhm.
pizza parlor who has a slippery pavement outside, and you go whoop,
Yeah,
and
they
you're
have
on
to
your
have a
bum.
maintenance schedule and a certain thing that would maintain it, and they have to maintain it up to a certain standard, so that they look at that standard, and if it's snowing all day, that this has to be done repeatedly throughout the day. So there has to be some care put into it and some definition of what's reasonable, to a reasonable standard. Like they don't expect about whole bunch of people with snowplows out there to make sure all the sidewalks are clear like every single minute of the day. But they
And
do expect that things are, you put stuff on it, salts, or there's this other thing that you can put on it too that melts the snow and can make it down to pavement.
yeah,
And then they check it later on, just to make sure. And most cities have bylaws requiring you to do your sidewalk afterwards. So but if something hasn't happened, or if the city has actually taken up that role, that they will handle the sidewalks, eh? And in many cases, even when you have to handle the sidewalks, the lawsuit goes to the city, because the
yeah,
city has to enforce the bylaw.
yeah. Okay, and as Roberts put it, you have a duty to look after the other person in the duty of care.
Absolutely.
Absolutely. Okay, let's move on to the standard of care. The standard of care is really determined based upon what actually happened. In the case of what we were talking about, the snail in the bottle, Donahue and Stevenson, it's a manufacturer of a product that has to be reasonably prudent in their processes to operate in a way that ensures that snails don't get in bottles. To put it bluntly, right?
Keep the snails in the bottles in 2 different rooms.
That's probably the thing about it. And potentially what happened in essentially what they believe happened in Donahue and Stevenson is the manufacturer of the soda pop left their bottles in a storage area, and for whatever reason, this storage area wasn't necessarily kept as clean as they may otherwise do, and they didn't. And for whatever reason, they didn't rinse it out on this occasion. Normally, they rinse these things out, check that bottles are clear, and they didn't. Right? Somebody slipped up. And depends upon where you are. So the standard of care is dependent upon the situation at hand. That also means that, for example, if you are injured on a shop floor or something like that, or in a workplace or something, it's all about what the standards are that exist within that workplace.
Exactly.
Yeah.
And then if you're a professional, that standard of care may be higher. And as a professional, there's also, if you are a fiduciary, if you're a trusted person, and you have to watch there, you even have a higher standard in terms of what you deliver, what the outcome is.
Yeah. And at the end of the day, what you're suing for is, of course, the breach of that standard.
Mm-hmm.
Right? And this is where, when the courts will look at it, as you say, your but-for test will come into play here.
Mm-hmm.
All right. So there's a whole heap of reasons, of course, why, and just because you slipped and fell outside of Joey's Pizza Parlor doesn't mean you're going to make a windfall. You've got to get through these hurdles.
Yep. And you have to prove that there was a negligence, and that burden is on the plaintiff. Yeah.
Yeah. And, okay, that burden of proof is on the plaintiff, and because we're talking here civil cases rather than criminal cases, that means that the judge or the person assessing the claim is essentially looking at 50.1% probable that the defendant was negligent.
Mm-hmm.
Right?
Like I once had a case where a town had a case against them where somebody drove over a pothole and it did some damage to their car. So the person stopped, took pictures of the pothole and everything else. It was a rather large pothole in the middle of the road, and there were other potholes too.
Yeah.
And then we sued the township, and then they came back and said, "Oh, we do this and that," and they actually showed that when they checked the road, when they filled the potholes up and everything else. At the end of the day, after we showed dated pictures of the potholes and everything else, and they went out to look at it, they decided to settle the claim.
Yeah. Okay, so moving on to another head of tort, we've got a thing called nuisance. And no, that's not you screaming at your next door neighbor, or that could be.
So you're talking Rylands versus Fletcher type nuisance.
Exactly here. And Rylands versus Fletcher is an interesting case. It's actually two neighbors. One has they create a plant where they actually need water to run part of the machinery in that plant, and so they dammed up a river. Trouble is, when they dammed up the river, what they didn't realize they were doing would be flooding mine works that were actually underneath underneath that particular river and underneath the floodplain which they created. And great idea, damming up the river to use it for power for their factory. Bad idea because it killed 30 miners. So the defendant, the plaintiff sued the defendant in this particular case because of the release of a noxious thing We don't think of water as noxious, do we?
Nope.
But put it in the context of those miners that were killed, that's damn noxious.
Mm-hmm.
Right? And it's an interesting case, that one. But there are many other examples of nuisance. Right? Rylands is not the only one, only example, but typically it tends to end up being, for example, accidental release of a chemical that floods into another area.
Mm-hmm.
Right? That type of thing is a lot of what happens with nuisance.
Yeah. And people have tried to go after cannabis plants where they've considered the smell and the production of it to be a nuisance.
Yeah.
I'm not sure how successful they were, but they've had to take steps to make sure that the smell didn't escape the plant and get into the neighborhood.
Yeah. Well, and actually, that is another area. For example, industries that release pollutants into neighborhoods have been, that's another example of nuisance suits.
Mm-hmm.
Right, and I'm sure 3 Mile Island might have got attacked by one from the villagers next to it. Right, back what was that, 1979?
Yeah.
So I'm sure they were kind of subject to a nuisance suit back those days. Okay, so moving on again, we've got conversion, which is the tort of theft.
Mm-hmm.
And essentially what's happened there is, let's say that, my kid left his bicycle on your half of the front lawn. We're neighbors. He left his bicycle hanging over your half of the front lawn. You picked it up, shoved it in the back in your shed. And my kiddo said to me, "Hey, Daddy, my bicycle's it's gone." All right, we look everywhere for it. It's not there. Right.
Mm-hmm.
Now, that's that's the tort of theft. If I find out later on that you've got it, I can sue you for conversion.
Mm-hmm.
There's another one that's very related, which is a thing called detinue, which is basically profiting from said theft. Not only did you nick my little boy's bike, you actually sold it or you rented it out. Rented it out. In fact, actually, some of the leading cases on this one are actually about like renting out for profit.
Mm-hmm.
Right? And I find that a kind of fascinating thing, renting out for profit. It was like we took somebody's car, but not only did we take somebody's car, we actually rented it out.
Might also want to look at trespass to chattel too, when you have issues where a piece of property has been violated, damaged, for certain purposes, like taking parts from cars and building other cars with it.
Well, that comes under the next category, which is trespass to goods.
Mm-hmm.
Chattels. The difference between chattels and goods, it all comes under the same category. Often chattels can't. Goods can be removed, but chattels not necessarily.
No, chattel is something that could be removed. It's usually a fixture.
Fixtures that can't be.
It stays there. Like if you're looking at renting out, say, a property, there's chattels and there's fixtures.
Yeah.
So that's part of the agreement, what you put about who owns the chattels and who owns the fixtures. And if you put the fixtures in.
There's another one here is, let's say you've got an electric lawnmower and unbeknown to me, you plug it into my my electric supply, outdoor electric supply.
Mm-hmm.
It's very similar related, very related. Yeah.
Yep. It's just things that happen all the time and things that we have to constantly look, because you have to address it. If you're trying to claim somebody committed a tort, you have to address the tort by its proper term.
Yeah. Okay. And then we've got trespass to person.
Mm-hmm.
Please explain.
Trespass to person, any kind of injuries to a person, defamation, slander, that type of thing. Assault, battery.
So they're all, so exactly. So our next set of ones, which, as I said, you said, first of all, defamation, libel or slander.
Mm-hmm.
So the difference between the two, so that people know, is one is written and one is spoken.
Yeah.
Right? Here, world, here's what I know to be true about Angela. Fake, fake, fake. Right? Whereas, hey, Angela, do you want to know what I know about George? That's slander.
Mm-hmm. Yeah.
Right?
Or we could talk about Peter's only fan page. Get everybody looking all over the web.
That's definitely slander. Especially since you broadcast it. Actually, under the definition of this particular,
This is a broadcast.
This is a broadcast.
Yeah.
So actually, it would be libel.
Mm-hmm. Yep.
Right.
And then they would have to send it there, and we'd have to withdraw a certain statement. So if he said something that was defamatory, it would have to be withdrawn. The portion of the recording has to be withdrawn. So if I said something that was libelous, and that would be an order. And then if it's not followed through, they can be sued.
Yeah. Okay.
Those that publish.
Yeah, and let's bring up another one here, which is intrusion of seclusion, or the tort of invasion of privacy. And the judges have to come up with a different word because they can't allow certain other concepts to come into law when they pre-exist.
Mm-hmm.
Intrusion of seclusion is basically me poking my camera, into, between, you've got slightly didn't quite draw your curtains enough, and I'm now taking my camera and picturing you having sex with your husband or boyfriend or whoever, right?
Mm-hmm.
Right? That type of thing is an intrusion of seclusion, because you have a private place, you expect in the privacy of your own home not to have me spying, or me or the world spying upon you.
Yep. See, it started off with the Jones versus Siege case, and that started where they developed this as a tort through the Ontario Court of Appeal.
Yeah.
And they allowed a maximum damages at that time to be $20,000. But then later on, there was another case where a person worked at the Royal Bank, I believe, and then she went into a co-worker's account and got information. I guess the co-worker was apparently having an affair with her husband or something like that.
Yeah.
And they got all kinds of information, and then the damages significantly went up.
Yeah.
So
the other thing about this one is this is Canadian developed, right? This particular tort is Canadian developed. It came out of Canadian law, Canadian court decisions, and it has actually being looked at in other jurisdictions as well.
Mm-hmm.
Right, so it's an interesting one. So now, one of the things we just talked about, trespass. Well, we talked about a whole conversion, debt in you, trespass to goods, trespass to people, defamation, intrusion of seclusion, and these could be negligent torts, but they could also be,
Intentional torts.
They could also be intentional torts, right? So intentional torts, though, include a whole heap of other things. Mm-hmm. For example, assault, battery, intent to inflict mental suffering. Right? And just so that people are aware of what the difference is, if I'm assaulting you, that doesn't mean to say I'm punching you. That just basically makes you fear that something imminent may happen, even though I didn't actually do it, didn't follow
through. Because it could be an act of intimidation or intimidating voice or movements, body language, things like that.
And it's like doing that, that kind of thing in front of a
battery is actually when you do something.
Yeah. And assault is when you haven't done something. Battery is actually when the fist made contact with the face type thing.
Yeah.
Right.
And we've had a very good case that we've tried, and we won on a case of sexual battery in small claims.
Yeah, that's true. That's true. The other one to look at here was the intent to inflict mental suffering. Now, likelihood here is there was, well,
Bullying.
could be it could be an assault, but there could be an assault which is actually going much further than just the pure assault there. It's just further than the actual physical threat. It's maybe it's an assault, and now I followed it up with, what I did to you the other day, I could make that 1,000 times worse if I tell your husband about our affair, type thing, right? that kind of thing, where that is intent to inflict a mental suffering, right?
Yeah, and it's also a form of bullying. If you're in a workplace and you're bullying, there is an intention to inflict mental distress.
Yeah, and in fact, actually, an intent to inflict mental distress is often
trying to get them to quit their job, that sort of thing. And
often in the workplace,
I've seen landlords trying to harass tenants into moving.
Yeah, and actually, there's the intent to inflict mental suffering is closely, of course, related to intimidation.
Mm-hmm.
Right? It's a degree that separates the two, really.
Mm-hmm.
Right? But one intimidation is more, I guess, the factor of, I'll get my boys on you.
Mm-hmm.
Type thing, whereas intent to inflict mental suffering might come about through words or implication.
Yeah.
Right. I send you I send you a series of emails, for example, that might well be graphical, not necessarily indicating something specific, but because of the type of email that is sent, that could inflict mental suffering.
Yeah. So these are things that can be done to a person. Like, you show that the act was done, and you have to show the proof of the tort. And in some cases, you don't have to prove damages, and in some cases, you do, depending on the nature of the tort.
Yeah.
Yeah. Defamation, for libel, for example, you don't have to prove damages.
Yeah.
Because you just have to prove that the statement is libelous. But slander, you do. There's other things too where we have.
Robert says the anticipation that something may happen, and that is certainly true for what we were talking about in infliction of mental suffering.
Mm-hmm.
Intent to inflict mental suffering. All right. So let's move on to then deceit. So this is kind of more or less an economic type tort, isn't it? Well, I suppose the typical ones are those scams that, hey, your bank account is overdrawn. Click here to, click here to correct the problem.
Mm-hmm.
Right.
Or somebody has got into your bank account, and we're here to check your account. So can you please give us your password so that we can fix it? And then they will be kept out. Yeah. Then you give them their password. The next thing you know, they drew all your money.
Yeah, exactly. Right. The next one here is injurious falsehood. Right. So you're actually committing injury here through a false statement or false actions.
Absolutely. And sometimes people have gone to the tips of that during the pandemic, although we've had to balance that out for people's freedom of expression and possibility of harm.
Yeah, and that's an interesting topic, because then you get into, when it's talking about words spoken, those you're getting into the well, what Peter Parker once called the responsibility that a journalist has about, there's responsibilities that they actually have, and he was talking about the responsibility A, as a journalist, and B, as Spider-Man.
Yeah. Like, say, for instance, if Joe Blow on the street says something, it may not count as much, but if Joe Blow were a police officer or if he were a lawyer, it could count for something.
Oh, absolutely. Or let's say, for example, your local city councillor gets up and says something bad about your business. Yes, it might well be defamation, but it also could, is an injurious falsehood as well.
Yep, exactly.
Right. It may not reach the levels of defamation insofar as, there's a sliding scale in these things, isn't there?
Mm-hmm.
And it's the typical thing of everybody knows that if you buy a burger from company X, they'll go rotten in your stomach, type thing, right?
Yeah.
And it's like everybody knows. No, they don't. The directors of company X don't know such a thing. They believe quite the opposite to be true.
Yep, right? Exactly. Yeah, like I remember one person, he used to go around and he used to tell people, don't eat at McDonald's. Don't eat at McDonald's. And everybody said, well, why? What's wrong? They serve people at McDonald's.
Yeah, they do serve people, you and me, if we go in there and want them.
Unless I think he's referring to some form of cannibalism or...
I don't know. Actually, that's interesting. Yeah. Okay. Another one here is passing off. Basically, what passing off is that, for example, at the top of our screen here, you can see our logo, Invictus Legal LLP. It's when somebody who's not part of our business actually tells somebody, hey, I work for Invictus and da-dee-da, right?
And even have her letterhead and blah, blah, blah.
Yeah. So they're doing something without the authority of the owner of like logos and things like that are typical.
Logos, letterhead, templates.
Yeah.
They have to be really, really careful. Like, even if you're an employee of Invictus for a while, when you leave, you can't start taking that kind of stuff with you.
Yeah. Well, the other thing about passing off is often, for example, we're an authorized dealer of Microsoft, right? We're a gold star dealer of Microsoft, but you're not. Have never passed a Microsoft certification in your life. That type of thing is a passing off issue. Right. Okay. Another one is conspiracy. And we're not talking here criminal conspiracy. We're talking here a conspiracy where you basically, let's say you're conspiring with another person to deceive somebody.
Yeah.
Right. It's where multiple people, it has relations to the criminal charge of conspiracy, but it doesn't
even conspire to do a civil wrong.
Yeah,
like two or more people working together to try to take over the company or to steal company secrets or to I don't know.
Exactly.
Yeah, but there's many different things that
and
they can do, and even towards a person too. And there could be.
And we could all of these ones that we've had here. We could conspire to we could together conspire to intimidate Joe because we don't like him.
We don't like him, so we're just going to decide that we're going to try to gaslight him collectively.
Exactly.
There is collective gaslighting. It isn't as common as someone manipulating and then getting everybody gaslit, but it does exist.
Okay, and this is another important one so that people understand about this one, is inducing a breach of contract. Essentially here what you're doing is you're making so it's again like it's like telling somebody in the McDonald's queue that, hey, McDonald's sell people burgers, right?
Yep.
So that person in the queue has just ordered or in the mid of ordering their thing, they overhear the conversation, say, cancel that, we're out of here, right? Except, of course, we're talking about, typically you're talking about a bigger ticket item than a McDonald's burger.
Yeah, like
like
we've had a case like that a while back where they've had somebody who went in there, actually was an interference with economic relations, but there was contractual relations involved, and the person knew what was going on with them. They kind of knew a little bit about it, so they induced this person to breach the contract, and in return for breaching the contract, the person would pay them. There's lots of different ways that they can do an induction of that.
And by the way, none of us believe that actually McDonald's do anything, feed any human products.
No, they that's the whole rumor of cannibalism has never been proven.
Absolutely, never been proven. We don't believe
I used to tease the guy about it.
And we're not going to.
I used to say, prove it.
And we're not going to accuse McDonald's of said things, right?
I know. Yeah. I don't think they've ever said anything like that.
But inducing of a breach of contract can actually be quite wide. Can be quite a lot of money involved in these sort of things. Induction, as you were saying, trying to take a high value employee from another company. It's an inducing a breach of contract.
Yep, you're doing a solicitation, which is in many companies they have non-solicitation clauses in their contracts.
Yeah, exactly.
And by doing so, going to some company and say, "Oh, you and I worked together, and you were bright. You were the brightest of the bunch there. So, I just started this new company over there, and I want you to join me."
Yeah.
And doing that. Usually what happens is the person can go with them, but there's usually a time period after that person leaves the company when they could do that. Like a year or so. So that there's no time for somebody just to do something like because I want to get back at that employer, And it does happen. There are lawsuits about that. That goes on, and sadly enough, they could be very successful lawsuits in terms of what damages the company has suffered, and that person could be responsible for paying for the damages.
Yeah, and interference with a contract or business relations is very serious.
Yep.
And we can be talking about there have been cases. There have been cases where the awards have been in tens of millions of dollars.
Absolutely.
Right. And you're talking about large international corporations who entered into contracts, and because of inductions to breach the contract have interfered with contract and business relations, and and sometimes even state relations.
Yep. Right. For example, one case that I was aware of about a year ago, there was a substantially large company. They've engaged and they got a multi-million-dollar contract, and it was just about to be inked. It hasn't been inked yet. But the person in the company that helped them ink the deal just moved over to another company and worked with that company to do the contract with the main party. And then the company that originally had the contract ended up having to sue.
Yeah.
You have to be really, really careful if this is what you're planning to do. You work for a company and you've done something like this and you've done a lot of work and doing this thing, moving over to the other side is probably not going to be a good idea, particularly when the board finds out and they decide that they're going to sue.
Yeah. And in fact, actually, from a legal representative viewpoint, you're not permitted to actually go work for the other side.
You can't.
Right. So if if you and I were opposing each other on a multi-million-dollar lawsuit, for example, and then I said, "Hey, Angela, we got a fantastic job in our X department for you, and we can pay you this fantastic salary," and you decide to come over, right? There has to be a Chinese wall between myself and yourself in relation to this, this particular case that we both opposed each other on.
Yep, and then there has to be some closure to the case from the previous firm.
Yeah.
There is a lot of stuff because you have to come clean.
Yeah.
And it's these things are very difficult. Like, I'd rather just avoid them altogether because I'm just one of those people.
Yeah, but again, people move companies for whatever reason.
Wrong with it, but you have to figure out how to do it. There are things that the Law Society does put in for guidance, just for legal representation. I'm sure it's for some other things too, like if you're an engineer or somebody like that who's worked in a company and then you're moving to another company, and you may be having maybe competitors. So there's probably rules for that too.
Yeah. Oh, yeah, absolutely. All right. And absolutely there are rules for that. All right. Anything else on breach of inducing a breach of contract or interference with contract business relations?
Well, that's a really interesting topic because I could probably write a whole book on that one.
I think actually there could be, because there's a lot of cases in this area.
Yeah, because it's business torts. Torts.
Yeah. Okay, another one is fraudulent misrepresentation, and that is also a business tort, but it can also be other, have non-business relations as well. But typically what happens with a fraudulent misrepresentation is that, hey, come buy my product. It's the best there is. It's the best computer you've ever seen. Not only is it the fastest on the market, it does X and Y and Z at a third of the speed that Apple or Dell or HP does. You've got to buy this tomorrow, right? And it's only $250, right? Now, of course, what happens when you buy it? That's absolute fraudulent misrepresentation. It's a heap of whatever, and
heap of junk.
Heap of junk, and probably built in China with substandard parts, and in 3 weeks doesn't even work.
Yeah, doesn't that sound like a computer reordered?
That does, yes. Yes, so that's what you call fraudulent misrepresentation.
And another way of fraudulent misrepresentation too is, say if I sent you as an engineer and I wanted you to do some research for me, I hired you or your company to go out and do some research, then you say okay, and then you accept the contract, you go out and you bill me and so forth, and you're sending me bills, and you did this, and this, and then you come up with a report of everything you supposedly found. And then I find out later on that the report was written based on, like, you didn't do any work. You just sat there and wrote a fake report.
Yeah.
Okay? That's a form of fraudulent misrepresentation.
This is me doing no work for you type.
Yes, exactly.
That situation, yeah.
Still expecting to get paid. That happens.
Yeah.
Okay? And sadly enough, too often.
Well, and I was going to say, there's a lot of instances where people go to work and they do nothing for half their day. That doesn't necessarily mean that fraudulent misrepresentation is going on.
Well, there's something called time theft in an employer situation.
Yeah,
where a person's kind of just sitting around dawdling their day when they're supposed to make X number of phone calls or whatever it is, that whatever the workplace requirement is. Right, scam.
I was just going to say, oh, you mean a ripe scam when we were talking about fraudulent misrepresentation? Yeah.
Well, these contracts that suddenly balloon to millions of dollars after they were only about 100,000 or something.
Yeah. Yeah, that's a $50,000 project that we paid, that our government paid 65 million for. That
Yeah.
is fraudulent misrepresentation with a triple capital F on it.
Yep, exactly. This happens a lot in government, and the thing is, they need better controls. Okay, they
And
need
that is precisely why this happens in government, because whilst it does happen, let's be honest, it does happen in across the business spectrum. We can fraudulently misrepresent to you as an individual. That's possible, and there are scams out there that intended to do that. There are also scams out there that are fraudulent, represent things fraudulently to businesses. So again, I try to trap your business and get you into it, and there's actually
we can handle all your SEO management.
Yeah, that type of thing,
And then they lead you down some garden path, and meanwhile you're paying all this money.
Yeah.
And
yeah.
nothing's being done.
Yeah, exactly. Nothing's being done other than what Google does by default.
Yeah. So what I do is, as a business owner, I don't take anything that we didn't solicit ourselves and research ourselves.
Yeah. Yeah. Okay. So that's fraudulent misrepresentation. There are a number of there are a wide range of torts, and anyway, and of course, what we have talked about here is that and go, so basically there is something that happened. There is a fault, and it could be either due to carelessness or intent, right? And to remind you, anybody can sue, which can be people or non-people, corporations, in other words.
Yeah.
Right. And even governments can sue.
Yep. Governments have
sued about that, right?
Like if somebody defrauded the government, like for one of those contracts, they have a right to go after them.
Yep. Absolutely. So that's something to remember, that you literally can open it up to everybody. Mm-hmm. So that's kind of where I think we're going to be leaving off. I'm going to remind everybody that if you're a lawyer or a paralegal, starting next Tuesday, you can go to the address here, and I put it into the links down beneath, and you can sign up for our CPD on managing client files effectively. So you can purchase this at CPD Legal, the address beneath, and happy to have you as part of the CPD.
Yep, 6 CPD hours, professionalism.
Yep.
I got approved by the Law Society.
Yep. And let me just say thank you to Robert. Thank you for being here, Robert. And I'm sure we will be seeing you another day. All right. And again, to finish off this program, if you need to contact us, the Invictus Legal LLP, you can do so by calling 905-688-5598. Or you can email Angela at angela@weareinvictus.legal. And please, no spam, right? or you can contact me at peter@weareinvictus.legal, or go to our website, which is https://weareinvictus.legal.
Yep.
And just one moment, we actually have a final thing. You're welcome from Robert. Okay. And of course, we are signing out with Angela's favorite part of the show.
Yeah, so what you heard today on Spin Legal, whether this show or others in this series, is not legal advice, even though when we talk about something, it may sound very similar to something that you're encountering or something that you may want to take action on. It doesn't necessarily mean you have a legal case, because there's multitude of issues that surround these issues. And it's best that you speak to a legal professional, a paralegal or a lawyer, before you move forward on it. Because the subject of torts is interesting. I've always found it interesting. But anyways, this is something that if you feel that that you have a case about that or anything, just talk to a paralegal or a lawyer.
Yeah, and in fact, actually, when you think about it, probably the vast majority of lawsuits that happen in this world, in this world, probably on the basis of tort. Things like personal injury, things like car accidents, that type of thing, slip and fall. All of that is on the basis of tort, right?
Yep. And then there's other things on contractual basis like wrongful termination, a breach of contract, substandard workmanship. Different things like that could also be considered in terms of that too as well.
And Angie says she loves torts.
Yep.
Yep.
Yeah, but the trouble is he doesn't feed me any of that.
And again, we're talking about torts that are suable, not the torts that you eat.
Yep, exactly.
But again, if you come to Invictus Legal, I'm sure that we'll find some torts that you can eat. All right.
Yeah.
So thank you. Thank you